Hi, I'm going to talk about the question of damages versus injunctions in the context of tree root subsidence damage claims and the case of Coventry versus Lawrence on this issue. Agreements to fell can often be used by defendants as a tactic when their trees are causing damage, either to mitigate loss, so avoiding underpinning costs and restricting a claim to superstructural repairs, or as a bargaining tool to secure an agreement from the claimant that they will not pursue a recovery altogether if, for example, a tree is felled at an early stage. However, there are occasions when clients do not want to fell their trees because they carry such significant amenity value, or there may be other public interest considerations at play. The case of Coventry versus Lawrence is useful to know in this scenario to save trees and defend injunctive relief proceedings. This case dealt with a noise nuisance arising from a speed racing stadium. However, it is also useful in tree root claims which are brought in the tort of nuisance. The February 2014 judgment dealt with, amongst other things, the issue of injunction versus damages. The four-stage test, called the Shelfer test, had previously been applied. This test prescribed that damages could only be awarded if there were four circumstances satisfied. Firstly, that the injury to the claimant's rights is small. Secondly, that claimant can be compensated in money. Thirdly, that a small payment would be adequate compensation, and fourthly, that it would be oppressive to the defendant to grant an injunction. But the Supreme Court criticised this test as being outdated and mechanistic and creating a presumption in favour of granting an injunction. Lord Sumption indicated that damages should ordinarily be an adequate remedy and that an injunction should not be granted where there are competing interests other than the parties concerned. Quite often, trees carry significant amenity and public interest must be considered. So we're not simply looking at the interests of those owning or controlling the trees. In conclusion, the Coventry versus Lawrence more flexible approach to awarding damages can be used with success in tree root damage claims to save trees and defend injunctive proceedings. But this will depend upon the facts and the expert evidence. For example, there must be no direct impact damage and no visual obstruction issues. This is useful to know, particularly given that the courts have not been deterred from granting injunctions since Coventry and Lawrence in noise nuisance and right to light nuisance cases.